And we are recording.
Okay. And did you want to do your announcement right now, Lisa?
Sure. Hi, I can see we have people signing on. Welcome. Welcome, everybody. We're going to give this a little minute so people have time to sign on. I'm Lisa from the Law Library. Welcome. Thank you so much for signing up for this session today. I'm going to disappear pretty soon and turn this over to our great speakers. But before I do that, I just wanted to say, once you leave the session today, you're going to see a link for a little survey. It shouldn't take you more than a minute or two to fill out. We'd really appreciate if you did that. Helps us know if we're doing all right with our programming, what you want to see, gives the speakers feedback. So please, once the session is over, if you do get have a moment or two, we'd appreciate if you'd take our survey. So I'm going to disappear and turn this over to our speakers.
Hi, guys, and welcome. I'm just so glad that you're joining us for Is Bankruptcy for Me? The goal of today's workshop is to not only help you to be a more informed consumer when it comes to being familiar with available alternatives out there when it comes to addressing a financial setback, but it's also just to help dispel some of the mystery and oftentimes negative connotation that might be associated with filing a bankruptcy. While the hope is that none of you will have to go through any type of dire financial situation, it's good to bear in mind that during the Great Recession of 2010, believe it or not, 1.6 million bankruptcy cases were filed. That was in 2010. At that point in time, the country carried just over $13 trillion in household debt. 13 trillion. At the end of 2019, just last year, the cumulative household debt was over 14 trillion. Well, in light of the COVID epidemic, it is anticipated that bankruptcies are going to far exceed the 1.6 million cases that were filed in 2010. With that being said, in addition to a number of other resources out there, bankruptcy is really going to be a lifesaver for many, many people, getting them on the road to a fresh start. This afternoon, you are in for what will prove to be an informational 40 to 50 minutes. Joining me today are two of my highly esteemed colleagues who are both well-versed in all things bankruptcy. Okay, if not all things, most things. So first off, we have, did we miss the screen, guys? Bear with me, got ahead of myself. So first off, we have Michelle Patterson of Michelle Patterson Law. Michelle began her career in bankruptcy in 2009 when she worked for a large multi-state bankruptcy and foreclosure defense firm. Michelle supported a team of attorneys who defended creditors in Chapter 7, 13, and 11 cases. Yes, basically she worked for the other side. My apologies to all the creditors out there, just joking, just joking. In any event, in 2017, she founded Michelle Patterson Law. Today, Michelle specializes in providing personalized services to debtors and individual creditors. She is a member of the California State Bar and the Federal Bar in the Central and Southern Districts of California. Also joining us is Dan Whitaker. Dan is a staff attorney with the Debt Relief Legal Clinic. He has worked in the area of bankruptcy for well over 13 years and has filed thousands of successful Chapter 7 and 13 cases. Dan is well respected in the bankruptcy community and is the go-to for not only myself, but for many of our colleagues. Dan's specialties are client education and communication. Suffice it to say, Dan is willing to go that extra mile to make sure that the correct financial solution is understood and implemented for his clients. So first off, let me do a big round of applause for my two colleagues joining me today. That's like a round of applause. I get it? Okay, anyway. So as for me, if I did not mention it earlier, my name is Pamela Brown-McGill. I have over 20 years working in the public sector, with over 10 of those years spent working for the Superior Court here in San Diego. I worked in the litigation department and more notably in the small claims legal advisor's office. I like to say notably because that's where I discovered my true passion, which is helping self-represented litigants navigate the legal arena. With that being said, while continuing to invest a lot of my time in putting on small claims workshops and clinics, as well as volunteering at other community workshops as often as I can, I also made it a point to add bankruptcy to my practice. Whoop, whoop. So this has allowed me to reach an even larger segment of the population, which may not necessarily have access to the legal resources that they need, right? So without a doubt, helping self-represented litigants is a true passion of mine, and I handle both chapters 7 and 13 cases. So with that being said, following is an overview of what you guys can look forward to over the next, say, 40 minutes or so. I'm going to start us off with a little appetizer, talking about some of the general and procedural information when it comes to bankruptcy, and I'll also provide you with an overview of the bankruptcy process as a whole. Then we'll jump into the meat and potato of what I'd like to call today's presentation, with Michelle covering chapters 7 and 11, and Dan will be educating us in regards to chapter 13. We will then wrap up with some miscellaneous tidbits, and then we will close out with questions and answers. So, and also just to confirm, I believe that you guys should have received the link for the handout. So it's up to you. You know, you can follow along on your computer. You can do your screen side by side, and you can also just print it out and take notes. Whatever works for you. This is just your handout. We want you to leave with as much information as possible. And then also at the end of that handout will also be a couple of additional resources for you to use once you leave here, as well as our contact information. So keep that handy. So moving on to what is bankruptcy. As a little bit of a precursor, although we often hear of businesses filing bankruptcy, such as General Motors, Chrysler, just this year there was JCPenney's, GNC, the reality is that actually many more individuals file bankruptcy than businesses by far. Some notables include, of course, our president, as well as Walt Disney. Did you know that Walt Disney filed bankruptcy? Apple came close. They didn't file, but they came close. Burt Reynolds, Cyndi Lauper, David Bowie, Abraham Lincoln, and Thomas Jefferson. I just thought it was really interesting to see, wow, these are really interesting individuals who have filed bankruptcy. So the takeaway is this: it happens, okay? And it happens to the best of us. So just what is bankruptcy? Well, bankruptcy is a court proceeding where the trustee and or the judge in certain circumstances is going to examine your assets and your liabilities, and then afterwards they're going to render a decision regarding whether or not you have to continue paying on the bills. That's bankruptcy in a nutshell, and it is governed, it's a federal court proceeding, and there are lots of laws there that cover what you can and cannot do in regards to a bankruptcy. The purpose of the bankruptcy laws is basically to give individuals who are facing these dire economic and financial gridlock the opportunity basically to start over. So I like it as kind of as your get out of jail free card. You get to use it one time, you're going to use it wisely. You won't get another opportunity when it comes to that again. So who can file bankruptcy? Well, you have almost anyone, right? Individuals can file. A married couple can file. They can file jointly or individually. And there are just a myriad amount of benefits to filing, whether it's individually or jointly. And that is something that you would definitely want to talk with an attorney or professional about, who could go into the technicalities of when this would be most advantageous. You also have your sole proprietorships out there, your LLCs, your corporations. So pretty much bankruptcy can be utilized by anyone, is what it really comes down to. What are your costs? Well, the costs are going to vary. The big two factors to kind of think of will be your attorney's fees and your filing fees. I know it kind of sounds a little bit of an oxymoron when you're thinking, oh my gosh, I'm trying to get from underneath my bills, but you're telling me yet that there are more fees to be paid. There are, but there are going to be ways for dealing with them. And so first off, when you're looking at your attorney's fees, the big thing to kind of keep in mind is this: your fees are going to vary. That's just all there is to it. It's going to vary by the law firm, by the attorney, as well as the type of chapter you're filing under. Generally speaking, your Chapter 7 is probably going to be the quickest chapter that you would be able to file under, whereas your 11 and 13s are going to take a little bit more time, a little bit more work, a little bit more effort. And so, therefore, the fees would be increased. However, when it comes to paying the fees, you do have a number of options. Some attorneys are going to allow you to make payment arrangements, and depending on which chapter you're filing under, there's also the option of possibly even having the fees rolled into what's called a plan. And again, what's going to happen is that when we get to the part of today's presentation where plans come into play, that will be discussed in more detail. In addition to having your attorney's fees, you also have the filing fees, and the filing fees are also going to vary. So here you're looking at a fee of about low 300s to in the mid 400s. Again, based on the chapter that you're filing. However, you can possibly get a fee waiver, and that's going to be totally dependent on your income. The court is the one that makes the ultimate decision in regards to if you can qualify for the fee waiver. Now, if you're sitting there thinking, well, you know what, I do have some funds coming in. I don't know if I'm going to be able to apply for a fee waiver. Well, still, all's not lost. You can also apply to have the fee split. So there are times when the court would allow you to pay the fee in, say, 2 or 3 payments. So there is still, the court is still trying to work with you. We don't want to foreclose this opportunity to those who really need it. So now, once, we know who can file, we know that there's costs involved, what's the process? Well, this is your process. That's it. Nothing fancy, nothing over the top. Just you're going to fill out your paperwork, right? Once you fill out your paperwork, you're going to file the petition in the schedule with the courts. You're going to pay the filing fee. We talked about that, the different ways to do it. You're going to attend a hearing. It's called a 341A meeting, and then you're going to get the discharge. Sounds easy enough, doesn't it? Wow, it's like, wow, why isn't everyone doing this? Right? We can all do this. Well, there might be a little bit of a catch. So what is the catch, right? You have to do your part. I did that first slide just so that you can see the overall picture and so that it didn't seem too intimidating. And again, I still don't want this to be too intimidating. At the end of the day, though, you have to do your part. And so how quickly your case progresses or does not progress is going to really depend on the work that you put in on the front end. So what does that work look like? Well, you have to gather information. Whether you're doing this on your own or you're utilizing an attorney or a paralegal, you're going to have to pull together a lot of information. And it starts with your income. What are your sources? Do you have a job? Do you have a pay stub? Are you receiving Social Security, unemployment? And the other thing to keep in mind is that it's not going to be enough for you to just show up and say, or just to write down, oh, I make $1,000 a month. No, we want to see documentation. When I say we, I'm talking about the court, I'm talking about the trustee. They want to see documentation. So you want to go ahead and pull that together. Another thing that you're going to do is you got to pull your bills together. I like to suggest for my clients, either I will pull the credit report or I have them do it. And the cool thing about the credit report is it does, well, first off, it's a reality check, right? You get your credit report and it's like, wait a minute, where did all these bill collectors come from? But the other nice thing is this, you're able to reconcile that with what you have on hand. If you're like me though, a lot of my bills are done online. So the credit report is great. And then I can just go to that resource and see what's there. But if you do get some bills in the mail, you can again reconcile it. There are 2 credit counseling courses you're going to have to take. One has to be done before you can even file, unless of course you've received some type of waiver or disposition from the court that allows you to forego the credit counseling course. So you do one before, you do one after, and then you can get to filling out the paperwork and filing it with the court. Your paperwork is going to consist of petitions and schedules, and at the end of the day, you are basically presenting your entire financial outlook to the court and the trustee for them to review. Once you file your petition and schedules, then you'll receive a hearing date. At this point, although that could change, but at this point, the hearing is set about 3 to 4 weeks out. once you get your hearing date, which is very quickly, you're going to make sure you submit the paperwork to the trustee. Remember a minute ago, I said you need to compile, your sources of income. You want to get your credit report. You want to get your bills. Well, you're going to send your pay stubs to the trustee. You're going to send him your federal income tax returns. So he does ask for he or she, depending on which trustee you receive, does ask for a fair amount of information. So you're going to send them documentation. Remember, we're asking for the court to forgive our debts. So it's only right that we provide them information that they can base that on, right? Now you'll appear at the hearing, and the hearing is actually called a 341A meeting. Believe it or not, this meeting is about 5 to 15 minutes. It's basically an opportunity for the trustee to get in there and clarify any questions he might have, clear up any kind of discrepancy that might show up. It's also an opportunity for you to explain, clarify, and update. Granted, I will admit it could be a very maybe the most stressful 5 to 15 minutes of your life, but listen, at the end of the day, there is definitely a silver lining, right? And that is in the form of a discharge. I have hearing there because periodically, just depending on what's going on, you may actually end up appearing at a hearing, but that Michelle and Dan will cover that when they get to the 7th, the 13th, and the 11th. So there you have it. In a nutshell, what's involved. It's not too bad, but the takeaway here is that it is going to require a little bit of work on your part. What if you need assistance? Keep in mind there are attorneys out there that do this. The beauty is that the attorneys will prepare the paperwork. They'll appear on your behalf. They can answer your questions. The paralegals can also prepare your paperwork, but remember, they can't give legal advice and they cannot appear at the hearing on your behalf. But there is assistance there if you need it, and we provided a resource list for you at the end of that handout as well. With that being said, Dan is going to just talk to you about some pros and cons.
Thank you, Pam. Pleasant Monday afternoon to all, and welcome to each attendee. On this pros and cons slide, there could be a laundry list of things to go over, but we'll just touch on a couple just to get your feet wet with a general understanding of bankruptcy. We'll touch on these two important subjects: exempt property and the automatic stay. For exempt property, the con here, meaning drawback of course, could be accurately stated that all rights to property must be listed in one's bankruptcy paperwork. This means legal and equitable, which means fair, rights in real estate, vehicles, personal property, business interests, rights to lawsuits, real or anticipated, such as potential work or personal injury settlements, and even property anticipated or not anticipated yet discovered within 6 months following the date of the actual case filing. Exemption in bankruptcy parlance refers directly to a property protection. So the pro here is that most items will generally be protected with the appropriate diligence. Verifying property exemptions or protections is one of the many reasons an individual should seek the assistance of a competent bankruptcy practitioner to ensure all that one has or anticipates may be protected. I have personally heard a number of horror stories over the years where an individual filed their own Chapter 7 case without the assistance of an attorney and unfortunately lost rights to one or more assets they could have otherwise protected with a little research and diligence in seeking professional help. The automatic stay refers to one of the most powerful injunctions, also known as court orders, that is put in place when any chapter of a bankruptcy case is undertaken. The pro for this item is that the injunction protects against creditors from further pursuing legal activity in all forms of collection, even if a collection lawsuit has already been undertaken. It also forces a stop to wage garnishments from a collection lawsuit judgment order, from a taxing authority such as the IRS or state departments of revenue, a levy from those entities, and from a levy put forth by a student loan collection and or any other civil court proceeding. The automatic stay is more or less the most powerful injunction in the land. The con for this item, though outwardly, as I've experienced with many clients, is that the automatic stay puts in place protection which prevents a host of different challenges like a difficulty in applying for credit, refinancing real or personal property, buying or selling assets, and all of these things are put on hold until a further court order can be obtained or the bankruptcy case completes by a dismissal or a discharge. So those things we generally don't hear about upfront, but learn thereafter once a case is filed, when a client is unhappy because they can't do what they want to do, which tends to be human nature. Okay. All right, so moving on to a term named venue. The legal term venue under American law is a concept distinct from jurisdiction. Jurisdiction focuses on the authority, the actual authority of a court to hear a particular case or matter. Venue is more concerned with the geographical location of the court where a lawsuit is commenced. For bankruptcy purposes, the law says a petitioner must reside in the county of the bankruptcy court for which they are filing for 91 of the last 180 days before the date the case is filed. In our locale, San Diego County, residents file their cases through the Southern District of California, San Diego. And the physical courthouse is located at 325 West F Street, downtown San Diego, 92101. Attorneys generally are required to file their clients' cases online, though there is counter assistance available at the courthouse for those individuals filing and representing, self-representing in their own case. If a bankruptcy petitioner is leaving a county they desire to file in, they must actually file their case before 91 days passes after departing the prior county, and then return 30 days after filing their required, for their required meeting of creditors that Pam mentioned a moment ago, and we'll talk about more on the subsequent topics. If a bankruptcy petitioner is traveling to a county that they want to file in, they must actually reside there 91 days before they can file in that county. A critical practical pointer, practice if you're an attorney or practical if you're not using an attorney, is to seek the advice of a professional for a free consult or just some advice before making a physical residential change decision. Because the bankruptcy petitioner's property that can be exempted, also known as protected, in a bankruptcy case varies from state to state, and the actual moving from one state can immediately and drastically affect what property can be protected. Do not try to figure this out on your own without the assistance of a bankruptcy professional. On the topic of consecutive bankruptcy filings, there is a general misconception floating around that one may file bankruptcy only once during a lifetime. This is legally incorrect and has always been. The bankruptcy code was established with the understanding that life happens, and one might need bankruptcy relief periodically throughout a lifetime. The tolling or waiting period between various individual bankruptcy case types is as follows, and is always measured filing date to filing date. Between consecutive Chapter 7 cases, 8 years. Between a Chapter 7 presumed to be completed and a new Chapter 13 case to preserve a discharge in that subsequent case, 4 years. Between a Chapter 13 case presumed to be completed and a new Chapter 7 case, 6 years. Between a Chapter 13 case presumed to be completed and a new Chapter 13 case, 2 years. The understanding of the interplay between the chapters of bankruptcy may sometimes be confusing. And there are additional rules and abilities between that described in the tolling discussed here, so one should, again, strongly consider consulting with a competent professional to correctly and completely consider a specific situation. I now turn the presentation over to my esteemed colleague, Michelle Patterson, who will take you on a smooth journey, we hope, through the rigors of Chapter 7 bankruptcy.
Good afternoon, everyone. My name is Michelle Patterson, and I'm going to talk to you about Chapter 7 bankruptcies. Chapter 7 bankruptcies are also known as fresh start cases, and they are also known as liquidation cases. And essentially what that means is that a Chapter 7 bankruptcy is the quickest path towards a financial fresh start. And what it may entail, or what it does entail, is liquidation of your non-exempt property or assets in order to pay off your creditors. As Dan mentioned previously, there's an exemption process. And if there's any property that is not exempt from liquidation, that property gets liquidated, and the proceeds are used to pay off your creditors with. Who can file a Chapter 7 bankruptcy case? Individuals, married or unmarried, and businesses. An example of a business that would file for a Chapter 7 would be a dissolved LLC or corporation, and also a sole proprietor business could file for a Chapter 7 as well. In this regard, I highly recommend that if you are a business owner and you are considering bankruptcy, it is best to take the time now and consult with an attorney so you can go over your options there. There are two ways to qualify for a Chapter 7 bankruptcy. One is based on your income and household size in your filing state, and the other one is based on the type of debt that you have. With regard to the first one, income and household size, what happens is we look at your total monthly income, or your average monthly income, and with your household size in your filing state, and we compare those numbers with the average household of your size in your filing state. For example, if you are married and you have a spouse and you have 2 children, you have a household size of 4. If you and your spouse are both earning income, we look at your total income between you and your spouse, and we also look at an average 4-person household in the state of California. And if you make less than that average, then you would qualify for a Chapter 7 that way. If you make a little bit more than that, then what happens is a means test is completed. And what's entailed in a means test is a deep dive into your expenses and how much you are spending on your household expenses in comparison with how the IRS thinks that you should be spending your money on those household expenses. Some examples of the expenses that we look at are your medical bills, your medical expenses, your food expenses, housing expenses, and transportation expenses. If by the end of the means test you are still making more money, then you would want to consider filing a Chapter 13, which Dan is going to discuss later. The other way to qualify for a Chapter 7 bankruptcy is if your debt that you have incurred is primarily non-consumer debt. What that means is we look at the type of debt that you have, and if 51% or more of it was not incurred primarily for the personal, family, or household purpose, then that is considered non-consumer debt, and you can qualify for a Chapter 7 that way. A couple of examples of common non-consumer debts are business debts, such as a small business administration loan, and also some tax debt. The general time frame for a Chapter 7 bankruptcy is about 3 months if it's running smoothly from the filing date of the petition. The process starts with you. As Pamela mentioned previously, you need to do your part. So at the very beginning, the pre-filing stages of a Chapter 7 bankruptcy, you need to take your credit counseling course before you file. Those courses are available online, and they take about an hour to complete. And once you complete the credit counseling course, you will receive a certificate of completion, and that will get filed along with your paperwork when we file your bankruptcy case. Another pre-filing stage that involves you is the document retrieval process. Most of us, attorneys, and I think even paralegals, we give you a long list of documents that we need from you in order to get the process started. And while we are receiving your documents and also information, such as a list of your property, real and personal property, including your cell phone and electronics and furniture and your vehicles and your condo or house, whatever you have an interest in, we need to know about it. And what we do is we look at the value of each piece of property and we plan for your exemption. So that way we can ensure that you're able to keep most of that property that you have an interest in at the end of the Chapter 7 bankruptcy process. Once your petition and your schedules and your statements are all completed by your attorney or a paralegal, if you've hired a paralegal to complete it, or even yourself, the last pre-filing stage is the signature process. And this is your time to really review your paperwork and make sure everything is complete and accurate. This is your time to remember any property you may have forgotten during the pre-filing process. If there's a bank account somewhere that you forgot about, even if you're not using it, but it's still active and you have $5 in it, we need to know about it now. If you have a piece of property in another state or even another country, we need to know about it now, because that way we can make the adjustments to your paperwork before you sign it. Because when you sign that paperwork, you are signing under penalty of perjury that everything in your paperwork is complete and accurate to the best of your knowledge. Once your paperwork is filed, your petition, your schedules, and your statements, then we receive a case number. The attorneys filed your paperwork electronically, so that case number is given to us immediately. And if you are representing yourself, even if you've hired a paralegal, you're still representing yourself, then you would go to the clerk at the bankruptcy courthouse. There's actually a picture behind me of what the bankruptcy courthouse in San Diego looks like. So you would go there and you would go to the clerk and you would file your paperwork there. Once your paperwork is filed, that means that your bankruptcy case is filed, and you receive a case number, and you also receive the date and the time and the location. 341A meeting of creditors, which is the one hearing, if your case is running smoothly, the one hearing that you have to appear for a Chapter 7 bankruptcy. That hearing is scheduled about 30 days after your bankruptcy case is filed. And when you appear at the hearing, you'll be at the hearing. If you have an attorney, your attorney will be present at the hearing, and so will the Chapter 7 trustee. The Chapter 7 trustee's role in your Chapter 7 case is to find anything of value in your bankruptcy estate that they can use to liquidate and pay off your creditors with. Again, there's exemption laws that allow you to keep a lot of property. So what they're looking for is property that is not exempt from liquidation, that is worth enough to liquidate and use to pay off your creditors with. They also they ask you a series of questions because you're testifying, again, under penalty of perjury. The hearings are recorded, and you are testifying to the trustee, the Chapter 7 trustee, that you've been truthful in your paperwork and at the hearing, and that everything is complete and accurate to the best of your knowledge, and that there isn't any kind of fraud. The U.S. trustee is also reviewing your case, and this is why it's very important, again, to be truthful in your paperwork. Because if the U.S. trustee, who doesn't appear at your 341A meeting very often, but if they do see something in your paperwork that may have been omitted or they need additional clarification, they will appear at the hearing as well, and they will ask you additional questions. And if that does happen, oftentimes the 341A meeting is continued out again, so it could give you time, you and your attorney, if you have an attorney, have the time to clarify anything that needs to be clarified. After the 341A meeting, you wait about 60 days. And during this 60-day period, it's your opportunity to take the second required course, which is the financial management course. You'll get a certificate of completion for that course as well. It's also available online, and that needs to be filed with the court to show that you have taken your second course. And your creditors have rights as well. If you have a creditor who thinks that they have a right to object to the dischargeability of any of your debt, they can file an adversary proceeding to object to the dischargeability of your debt. That usually happens in a fraud type of case. So again, it's very important to be honest up front if you have an attorney, so that way we can tackle these issues from the beginning before we've even filed. At the end of the 60-day period, you receive an order of discharge from the bankruptcy court, and that is the main goal of a Chapter 7 bankruptcy case. What that does is, I actually have an example on the next slide. This is an example of a discharge order. And the discharge order basically states that all of the debt that was incurred prior to your bankruptcy filing is now discharged, meaning that you are no longer obligated to pay all of that debt. There are a couple of caveats, however, as you can see on the right-hand side of this screen. It says that some debts are not dischargeable. So even though the majority of your debt will be dischargeable through a Chapter 7 bankruptcy through this discharge order, you have to be aware that there are certain debts that are not dischargeable. And common examples would be spousal support, child support, those are called domestic obligations, student loans, and some tax debt. So just be aware that even though the main goal of a Chapter 7 bankruptcy is to receive that discharge order that says, I no longer have to pay this debt, there are still certain debts that you are still responsible for at the end of the case. You might be asking yourself, what about my car or my home, or I might be paying off some furniture at Jerome's, or I might have a tax lien or a judgment lien. That is called secured debt. Secured debt is debt that is attached to property or secured by property. You are paying a debt in order to keep this property. And the common examples are your vehicle or your home, and judgment lien, or furniture that you might be paying off. And then there's also judgment liens and tax liens that those eventually get paid through your property. There are two components that you need to be made aware of for secured debt. One is your personal obligation, your personal liability. That is, that means that you are obligated to pay that debt in order to keep the property. What happens though with a Chapter 7 bankruptcy through that discharge order is your personal obligation on that debt is actually discharged through that discharge order. You're still responsible for paying it off. So for example, you want to keep your car, and you're still responsible for paying for the car even after the Chapter 7 case is over. However, if you don't pay for that car, then the creditor has the right to take that car back. So that's the second component of a secured debt. The creditor's legal right to take the property back if you default on a payment. That's their security interest. So in sum, with regard to a secured debt, your personal obligation is discharged through a Chapter 7 discharge order. However, you still have to pay for it after your case is over in order to keep the property, because if you don't pay after your case is over, the creditor can still take it back. But the difference is that obligation that you're personally liable for also goes away with that property. There are three options that you have for secured debt in a Chapter 7 bankruptcy. The first one is surrender it. So say you have a vehicle and it's just too costly for you to make the payments and to pay for the insurance, and you've been behind on your payments before you even filed the Chapter 7. In that case, you have the option to just surrender the property, give it back to the creditor, and then you're also walking away from the debt. The second option is to keep the property and continue to make regular monthly payments. The caveat here, though, is that the property needs to be exempt from liquidation and you need to be current on your payments. If you're not current on your payments, that is when you would talk to your attorney so they can discuss your options with you, because that might come to a point where you may decide to just surrender the vehicle, or you can make other arrangements with the creditor, such as a reaffirmation agreement, which will be discussed later. The third option is to redeem the property, and that simply means that you're paying the fair market value of the property to your creditor in order to keep the property. The other type of debt that is handled in a Chapter 7 bankruptcy case is unsecured debt. And that is debt that's not attached to property. And that's actually the most common Chapter 7 case that you will see. You're discharging credit card debt, medical bills, and personal loans, debt that is not attached to property. And that gets discharged through that discharge order that I just showed you previously. But just remember that there are certain exemptions to the dischargeability aspect of the discharge order, such as student loan debt and certain tax debt, which are also unsecured debts, but they're still not dischargeable. Okay, so I'm going to pass the baton on to Dan, and he's going to talk to you about Chapter 13.
All right, thank you. This program is commonly known as, actually in the bankruptcy code, is known as Chapter 13, Adjustment of Debts of an individual with regular income, though understood more commonly as personal or individual reorganization. Chapter 13 is also known as the wage earners bankruptcy. Chapter 13 bankruptcy should not be confused with a debt consolidation service one might see as an advertisement offered on late night cable television commercial or heard on a radio program. Those debt consolidation programs are not classically based in any form of law, as they are voluntary to and for the creditor. Actual Chapter 13 bankruptcy is a way to legally consolidate and or adjust one's obligations. Waiting for the advance here. Let's see. There we go. Who can file Chapter 13 bankruptcy? Chapter 13 is a program by which an individual can restructure his or her debts and provide for payments to creditors using a relatively simple and inexpensive procedure. Only individual persons and sole proprietor businesses are eligible to file Chapter 13 case. Corporations, partnerships, and other business entities that have their own legal distinction, also known as an entity, cannot file Chapter 13 bankruptcy. The individual debtor must have regular income, such as wages or income from self-employment. When is a Chapter 13 case most appropriate? As the slide indicates, those are 4 bullet points, and I'll add some flesh to each one of those. An individual that may have too much income to qualify for Chapter 7 consideration. What does that mean? Well, as Michelle indicated in the Chapter 7 process, part of qualifying includes providing 6 months proof of pay to your attorney or yourself if you're doing the processing yourself, and putting it into the formula that helps determine if your income exceeds, and they call it current monthly income. And many things can make up current monthly income, and we'll talk about a few of those as well. But if that current monthly income exceeds the national standard for median income for your locale, you might be forced to do Chapter 13 instead of Chapter 7. I mentioned the media income, and that standard is set up by, I believe it's the Internal Revenue Service, and it is specific to each county. So every county has its own median income standard. So all attorneys' bankruptcy software has to be synchronized with that. Also included in income could be bonuses, atypical or regular, or lump sum payments of kind. It is quite a laundry list of what is considered income. Things that are not considered income: Social Security Administration payments, whether they be periodic in a monthly form or lump sum benefits as a result of disability litigation. Those are all exempt and not counted as income and protected assets, which is a nice benefit. Also, qualifying VA disability payments, as of a recent change in law, are no longer counted as income, which is also great. Another item, the second bullet point item, individual that has assets in excess of what is protectable by the applicable state law scheme, exemption scheme. What are examples of things that might be in excess of the exemption scheme? Well, let's say you have a residence, and the equity you have in your residence is above the dollar amount that the state where you live allows you to protect for that equity. You may be forced into Chapter 13 bankruptcy to pay the excess of that equity in the form of your general unsecured creditors, which we'll talk about in a few moments. Also, other tangible personal property assets, such as an excessive number of vehicles, or toys, such as quads and trailers and fifth wheels and those things. So all of those have to be taken into account. Also, your rainy day cash fund, if you have one, or a savings account that's in excess of the allowed exemption amount and does not have a qualified internal revenue code or ERISA designation, such as an IRA or 401k. If you have liquid cash, it might force you into a Chapter 13 bankruptcy. Additionally, bullet point 3, an emergency situation. What are those? Possibly you have a residence that you haven't been able to pay for a while, and you're trying to reorganize that in a Chapter 13 plan to avoid a foreclosure. That's an emergency. The imminent or loss that's already happened of a motor vehicle. You can get a motor vehicle back within a certain amount of time by law using the filing of a Chapter 13 case. Or if you're behind and you're afraid of imminent repossession, Chapter 13 stops that repossession. And lastly, on the emergency scheme of things, let's say you were sued some time ago and ignored it. Let's say you didn't honor your tax obligations for a certain year, and now the state of California and the Internal Revenue Service are calling by form of wage garnishment, wage levy. Those wage garnishments can be real dangerous, especially if you live in Southern California, you're below median income, and you're a single wage earner, and you're about to lose 25% of your net wages. Chapter 13 bankruptcy can be a way to stop that immediately, because in Chapter 13 bankruptcy, as Pam's going to discuss in a little bit, you don't have to pay a legal fee up front to get a case on file. You don't even have to pay the expenses. Depending on the attorney you're working with and the process you're going through, fee waiver, etc. It's possible that in an emergency situation, Chapter 13 may be more appropriate than a Chapter 7. I have 2 more items on here. The 4th bullet point, conversion from a Chapter 7. That's not a very common occurrence, but Chapter 13 may be used as a conversion device from a failed Chapter 7 attempt, or some other unknown circumstance not discovered or known on the date you filed your Chapter 7 case, such as you received inheritance, lottery winnings, knock on wood, insurance settlements, or any other life happening. Stuff happens. You're in the middle of a Chapter 7 case, and then lo and behold, you inherit $100,000. What do? Well, my advice is go see an attorney and let them help you flesh that out. But that may be a reason to convert to a Chapter 13 to pay either all of your creditors or a subset of them, which we're going to talk about in a moment. The item I don't have on the slide here, and I'll just explain it quickly. Chapter 13 can be used if one thinks they might need to later voluntarily pull the plug on their bankruptcy case, which is known as a voluntary dismissal. Chapter 13 is a great tool if a voluntary dismissal is contemplated as being needed, as a Chapter 7 case may not be voluntarily dismissed. Once one is in a Chapter 7 case, one is in. The 3 options from that point are to successfully complete the Chapter 7 case, file a motion to convert the Chapter 7 case to a Chapter 13 case, like I mentioned, in some form of need to convert because of an inheritance or such. Or if a dismissal of a Chapter 7 case is absolutely an absolute necessity, in which case you need to place a motion before the court for an order, and of course your Chapter 7 trustee receives notice as to the reason why your case needs to be dismissed. But it's a very serious matter. Chapter 13 process. Who oversees a Chapter 13 bankruptcy case? Unlike in a Chapter 7 case where the Chapter 7 trustee is responsible for the administration, subject to the oversee of the Department of Justice via the United States trustee, the Chapter 13 trustee essentially handles most of the administration in-house. The trustee position is a position of extreme responsibility, appointed to employment by application to the government. And the trustee has these examples of duties. This is some of them, but not all of them. The trustee is responsible for reviewing the paperwork, just like in Chapter 7, where you have to put forth a petition and schedules in support of your case with the supporting documents. You have to do the same thing in Chapter 13. So the Chapter 13 trustee is responsible for reviewing that and your proposed Chapter 13 plan, which we'll talk about on the next slide. Or, yeah, I believe it's the next slide. As well, the Chapter 13 trustee holds a meeting of the creditors examination, where the petitioner is placed under oath and is usually briefly examined about their documents and financial situation to figure out if they're correct and if the plan being proposed is proposed in good faith. And we'll talk about that in a moment. The trustee reviews each creditor claim. When you file a Chapter 13 case, your creditors are allowed to participate in that case, unlike in a Chapter 7 case. Therefore, the trustee has to review the claims that are submitted in the case. The Chapter 13 trustee litigates with the petitioner before the court to settle any disputes or inconsistencies with the testimony or the paperwork, or what is being proposed in the plan. Once all trustee and creditor disputes are eventually resolved, the trustee signs off on the final Chapter 13 plan and takes the eventual approved plan payment that the petitioner proposes for the duration of the plan. And we'll talk about the duration on the next slide. The trustee then distributes the petitioner's plan payment to the allowed creditors according to their priority in the approved plan. Also, an overseer, of course, in every case, but importantly in Chapter 13, because they're more visible, is the bankruptcy court judge. Think of the bankruptcy court judge as the arbiter of any dispute in the case against the petitioner. What does that mean? I like to analogize the judge as the parent who arbitrates between arguing siblings who can't get along. Who are the siblings? Well, the Chapter 13 petitioner, client filing the case, and of course the Chapter 13 trustee. If you can't get along with him, you end up in front of the judge. If you can't get along with your creditors and figure things out there, you end up in front of the judge. So the bankruptcy court judge can be your friend, especially if you're an attorney, and you dot your I's, cross your T's, and do everything the correct way. They're there to advocate, of course, neutrally for a good faith filed case. And lastly on this list, bullet point is creditors. Well, why would you, how could a creditor oversee a bankruptcy case? Well, you'd be surprised. In Chapter 13, since the body of creditors are allowed to submit a claim, well, who's going to review that claim? The trustee is going to review the claim. The petitioner is going to review the claim. Well, what if it's incorrect? Lots of idiosyncrasies and tributaries involved with creditor submissions and whether they're valid and all of that. So there's a process for objecting. There's a process for resolving. So if a creditor wants to make a Chapter 13 bankruptcy petitioner's day rough, they can throw a claim up in the case and force delay things because the approval process is based on the Chapter 13 trustee and the body of creditors approving to the case. So if they don't, then there's inherent delay in that process of resolving those disputes. Each of the creditors who desire to participate must submit a claim if they're going to, for the petitioner to consider and the trustee and have the right to be heard. So this right gives a creditor some overseer control in a Chapter 13 case. What is a Chapter 13 plan? Well, in addition to the petition and schedules that are filed with the court, like similar to a Chapter 7 case, the plan basically tells the trustee what is going to be paid. So in support of the schedules and statements required to be filed with the court, much similar to the Chapter 7 bankruptcy Michelle discussed a bit ago, the Chapter 13 plan is the primary document the Chapter 13 trustee uses to determine the priority in who he makes payments to and how much, and who he doesn't make payments to. Typical sections in a plan, usually in order of placement or by verbiage of priority, are the plan payment dollar amount and the length of the plan. What does that mean? Well, a plan, Chapter 13 plan by bankruptcy code definition of law, is either going to run 3 years or 5 years or some time frame there between. And what determines that is if you, that's called the applicable commitment period. What determines that primarily is your statement of current monthly income, the means test that Michelle described earlier. And if your income is above the median income for your locale, you're automatically committed to 5 years. So there's a lot of nuance and a lot of strategy involved with a good Chapter 13 plan. If you're below median income, the applicable commitment period is 3 years. Can you run longer? Of course you can run longer, but that's at the discretion of your attorney, the result you're trying to achieve, and of course, with the oversee of the Chapter 13 trustee's approval and the judge rubber stamping what the Chapter 13 trustee approves, is willing to approve. Also in the plan can be administrative fees to be paid through the plan, such as your attorney fees. Real estate arrears, a plan is designed to cure real estate arrears. If you have a home and it's going into foreclosure, you want to avoid that. This is one of the primary reasons for Chapter 13. Chapter 7 does not allow for that. If you can't pay your home and you can't modify your loan, you're probably going to lose it beyond a Chapter 7 case. In Chapter 13, you can keep it. However, there's some work to do, whether it be loan modification or curing the arrears that you got behind before filing your case. Vehicle issues can also be resolved through a Chapter 13 plan. And there's a neat little distinction in the law that says that if you've owned your vehicle more than 2.5 years since the purchase, you can pay fair market value for that vehicle through the plan. And the vernacular is a cram down. So cramming down a car is one of the most popular uses of a Chapter 13 plan. Also to pay back priority obligations like income taxes, which we'll talk about in a few moments, as well as domestic support obligations. Importantly as well, there's a misconception that all of your debt has to be paid back in Chapter 13. And I'll talk about in another paragraph coming that's not necessarily true. Chapter 13 is designed to pay what has to be paid, your home, your car, taxes, domestic support obligations, and then what you can afford to pay, which is very cool. So it's not necessary, depending on your financial situation, that you pay all of your debt back. Once a plan is, there's also, I skipped over a few items there. Let's talk about them quickly. There are also special treatment for lease obligations, co-signing obligations.
If I may, real quick.
Yes.
I do see that it is going, we're just coming upon the 1 o'clock hour. So I want to thank all of our attendees for being so patient and hanging in there. Admittedly, there is a lot of information we have for you guys. So what we're going to do is Dan's going to go ahead and finish wrapping up this section. And then there is a comparison chart for Chapter 11, which Michelle will just spend like 30 seconds pointing out to you, and we will wrap up shortly. So thank you for hanging in there, guys. All
right, should you how wrap up this section?
Yes, go ahead and wrap it up, buddy.
Okay, all right. As I said a moment ago, it's important to note that Chapter 13 bankruptcy does not require a petitioner to pay all his debts back, which is the misconception I spoke of a moment ago. But what debts must be paid back? Homes, vehicles, taxes, support obligations, and a portion of the unsecured debt, which is credit cards, personal loans, medical bills, etc. It's also important to understand that it's possible to modify a Chapter 13 plan after it's been approved based on changed circumstances. So it's not engraved in stone, but it is advisable. To seek the advice of an attorney before moving into the deep waters of Chapter 13 bankruptcy. Now I'm going to turn the presentation back over to Michelle, and she'll speak about Chapter 11 reorganization.
Okay, Chapter 11, it's just very quickly in the interest of time. They're also known as reorganization bankruptcies and business bankruptcies because traditionally businesses are what file a Chapter 11. As Pamela mentioned earlier, we're seeing a lot in the news lately of large businesses filing for bankruptcy, and this is the type of bankruptcy that they are likely filing. It's also important to note that about a year ago, last summer, Congress passed the Small Business Reorganization Act. And what that did was that amended the Chapter 11 section of the Bankruptcy Code. It's called Subchapter 5. And it amended the code to account for and allow for small businesses to reorganize their debt in a Chapter 11. So here is a comparison, just a very brief comparison of the traditional Chapter 11 case. As you can see, individuals and businesses can file Chapter 11s. For the under the SBRA, the Subchapter 5 case is for a small business debtor, and that is a debtor engaged in business and commercial activity. Essentially, the difference between the two is, it's a few differences, but the costs can be a little bit less. They're both still very expensive, but the cost is a little bit less for the small business debtor. And there's a debt limit for the small business debtor as opposed to the traditional Chapter 11 that has no debt limit, and the time frame for both types of cases. Traditional Chapter 11 cases can go on for years. Just to get a plan confirmed. But the Subchapter 5 case it's geared towards facilitating and speeding up the reorganization process for the small business debtor. So if you have the handout, look at this chart, and if you are a small business debtor or just a business owner and you're trying to figure out what your options are, I just highly recommend that you speak with an attorney. And now we have some miscellaneous items that Pamela is going to start off with, if we have time.
Bear with me. I'm playing with trying to, there we go. I just wanted to go ahead. And Dan, why don't you go ahead if you want and top back on screen. For the sake of time here, because I know we are running out, just to real quick to recap, I did go over the attorney's fees early on in the presentation, just explaining that the fee is going to vary and there are going to be various ways in which you can handle it. The thing to keep in mind in regards to attorney's fees as well as reaffirmation agreements, which can both be a little bit complicated at times, what you're going to want to do is just definitely talk to an attorney about both of those issues. What I really want us to do is just get to any questions that we might have. And as Lisa's going through her list, Dan, if you'll just briefly touch on leases, and then Michelle on taxes and student loans, just to the extent that they can be dealt with.
A less common and more nuanced issue in bankruptcy is real or personal property lease. Lease, just in layman's terms, is just a rental agreement. And it's a very serious thing in bankruptcy because in Chapter 7, the Chapter 7 trustee has the right of first refusal to assume or reject a lease. And if the Chapter 7 trustee does not exercise that right in a period of time, the debtor has the right to assume or reject the lease. In our practical situations, we typically ignore the lease assumptions, but in some cases, if it's a goal to work with the creditor long-term, they press for a lease assumption, especially for aggressive creditors. And the point to keep in mind is that a lease assumption should not be taken lightly because it does not have independent court review, which means if you sign it, you're on the hook for the terms of the original lease agreement. So expect to be bound by it in every form or fashion. And the most common, of course, are 24, 36, and 48-month car leases. and kiosk and storefront leases. But just keep in mind those kinds of things. And I'll just mention quickly about asset purchase, sale, and refinance during a bankruptcy case. It's just important that in all of those cases, you're probably going to require court approval. So your trustee is going to know about it, the court's going to know about it, and none of this stuff happens easily without the knowledge of the trustee or the court.
I'm actually just going to skip straight to student loans because I feel like that is a hot topic that we see on the news a lot, and almost everybody has student loan debt. Just know it's, as I mentioned before in the discharge order, student loan debt is not dischargeable. However, it's not impossible. And if you think that you are somebody who could qualify to discharge their student loan debt, just know that there's a lot of planning and litigation involved, but it is not impossible. And there are actually current trends in the courts right now that are allowing partial discharge. So just know those few points about student loans because they are at least popular questions that we're seeing, and we're seeing it on the news a lot. So.
Perfect. Thank you, Michelle and Dan. Lisa, did we have some questions out there?
We do not have any questions at this time. So since we're a little bit over time, unless somebody has something really quick that they want to put in Q&A, we're going to go ahead and wrap up.
Perfect.
I think you covered everything, so nobody has any questions. Either that or they're being shy here.
Perfect. Well, thank you guys for attending. Appreciate it.
Thank you very much.
Okay, I guess that's it. Oh, we have one. Okay, let's go. We just have a comment, not a question. Thank you for the lesson. Thank you for your comment.
Yes.
Thank you.
All right, thanks so much. And this video will be going up on the San Diego Law Library YouTube channel within a couple days. So if there's anything you wanted to review, it's going to be there. And just let us know if you have any questions or didn't get the handout at refdesk, REFDESK at San Diego Law Library.org. And please take our survey if you have a moment. Thanks so much for attending, and thank you to our speakers today.
Thank you, Lisa.
Thank you for having us.
Thank you.
Thank you for organizing this.